Hello and welcome. This is a recording of a seminar the Sentencing Advisory Council recently presented for Swinburne University's Centre for Forensic Behavioural Science, and which we've recorded because we wanted to make it available for everyone. I'd like to begin by acknowledging the traditional owners and custodians of country throughout Australia, and especially the traditional custodians of the land where this work was done. Right now, I'm coming to you from the land of the Bunurong people of the Kulin Nation, and the Council's offices are on the land of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders past and present, and I also acknowledge Aboriginal and Torres Strait Islander people watching this recording. This is a discussion of our recent research on stalking. That research culminated in a report entitled Sentencing Stalking in Victoria, which was released in March and is available from our website. My name is Anna Chalton. I'm a Senior Legal Policy Officer at the Sentencing Advisory Council, and I was the lead author on the stalking report. For those of you who don't know, the Sentencing Advisory Council is an independent statutory body established under the Sentencing Act 1991. Its mission is to bridge the gap between the community, the courts, and government by informing, educating, and advising on sentencing issues. Our statutory functions include providing statistical information on sentencing, conducting research and disseminating information, gauging public opinion on sentencing, and consulting on sentencing matters with the government, relevant bodies and experts, and with the general public. To do that, we produce a range of products. Those include reports, for example, the stalking report. We also have a range of other recent reports, including one on threat offences and a series about crossover kids involved with both the child protection and youth justice systems. We also produce statistical tools. That includes our SACStat database, which tracks sentences for every Victorian offence sentenced in the Magistrates' Court and the higher courts, and our sentencing snapshots, which include in-depth data on a selection of important offences. That's the Council. The background to this report is that it was undertaken to assist the Victoria Law Reform Commission with their work on stalking. As part of that work, they were asked to look at sentencing practices and available sentencing options. Their interim report was released in April, and the final report has been prepared. It will be made available on their website when it's tabled in Parliament, which should be later this year. To help them with that work, we looked at, first, the prevalence of stalking offences in Victoria. By that, we mostly mean recorded crime statistics. Second, we looked at the sentencing of stalking offences. And third, we looked at subsequent offending among people who were sentenced for stalking in the Victorian courts. The study period was the 10 calendar years from 2011 to 2020. I'm going to start by providing some background information about what stalking, the behaviour, might look like, and also what the stalking legislation can capture. Those two things, the behaviour pattern and the crime, are not always identical. Generally speaking, stalking can be defined as a pattern of intruding into another person's life in an unwanted way. Depending on who's defining stalking and why, there might be variations in the definition. But those features, that there's unwanted intrusion and that it's repeated or ongoing, are fundamental. That definition could capture a wide range of behaviours that occur for a number of different reasons. So one typology that we found quite useful, although it's certainly not the only one, classes stalkers by their motivations. Rejected stalkers perceive themselves as having been rejected by someone who's very important to them. That's often, but not always, a former romantic partner. Resentful stalkers stalk because they think that they've been done wrong, perhaps by the victim personally, or perhaps there's a more general sense of grievance and they resent the victim's apparent success. Predatory stalkers stalk as preparation for another crime, perhaps a sexual crime. And intimacy-seeking stalkers and incompetent suitors stalk to get closer to the victim. For intimacy-seeking stalkers, that's because they're convinced that the victim either already does, or in the future they will, return the stalker's love. For incompetent suitors, it's because they want to form a new emotional or sexual connection with the victim. There's a high rate of mental illness and of neurological or developmental issues among people who stalk. And stalking behaviour can vary a lot in terms of intensity, how threatening or violent the stalker might be, whether the stalker fixates on one person for a long period of time, and whether they have multiple victims. All of that can contribute to different victim experiences, and what a victim experiences is deeply personal to them and situationally dependent. But there has been research on the harms of stalking that identifies common effects, and those harms can be significant. They often include significant fear and anxiety. Victims sometimes also experience social stigma. Many victims experience symptoms of mental illness related to their experiences. And these psychosocial harms tend to be more significant where the stalking has been very intense and/or it's occurred over a long period of time. And of course, there's always the risk of physical harm. So the risk that the stalker might physically hurt either the victim or someone close to the victim, such as a new partner. Finally, I just want to make the point again that what's captured by the stalking offence doesn't necessarily map perfectly to what a psychologist or a criminologist would classify as stalking. And that's partly because its focus is different. For the criminal law, the effect on the victim is very important, as well as the intention or mindset of the offender. So what does the offence cover? In Victoria, stalking is defined in Section 21A of the Crimes Act. That section was first introduced in 1995 to provide a remedy to people, particularly women, who had been followed, placed under surveillance, contacted, or been sent offensive items in circumstances where the offender intended to cause them physical or mental harm, or apprehension or fear for their own or someone else's safety. The offence has three elements. First, there has to be a course of conduct, meaning either a series of different acts or a single protracted act. And this requirement captures the pattern or duration element of stalking. But a course of conduct has been quite broadly defined in stalking cases. For example, we have cases that have said that sending 9 different letters all in one go is a course of conduct because it's a series of acts. And placing a phone in someone's car boot to GPS track them over a few hours is a single protracted act. The second requirement is that the course of conduct has to consist of one or more prohibited behaviours. And there are many of those. This is a screenshot of the offence. About half of what you see here is the list of prohibited behaviours. They include following the victim, contacting them, threatening them, publishing things about them on the internet, and so on. There's also a catch-all at the end, which captures acting in any other way that could reasonably be expected to cause the victim physical or mental harm or arouse apprehension or fear for their own or someone else's safety. The third requirement is the mental element, which is that the offender either intended harm or actually realised that they probably would cause harm, or in the circumstances the offender should have known that harm was likely and they actually did cause harm. The maximum penalty is 10 years imprisonment, which is the longest in Australia, and it's also high by international standards. And because the offence can be committed in so many different ways and with multiple different states of mind, it can be used quite flexibly. As part of this project, we read all of the publicly available sentencing remarks and some non-public ones that the courts provided to us for stalking cases in the higher courts within our reference period. We found that the offence covered quite a lot of different scenarios, ranging from short, intense bursts all the way up to multi-year stalking episodes. And they included quite a variety of different behaviours. So to demonstrate that, I've pulled out 2 examples from those higher court remarks. Our first case, DPP and Stevens, was a case of long-term fixated stalking. The offender was a mature student. He had seen the victim at university. He addressed her by name and added her on Facebook. And she was confused by that because they'd never actually met before. And then he kept making contact. The charge sheet specified 30 days on which messages were actually sent, but the whole trajectory covered a 5-year period. The stalking got worse and the threats became incredibly explicit and violent when the victim initially went to police but didn't proceed with charges, when she obtained an interim personal safety intervention order, when the offender was arrested, when the personal safety intervention order was made final, and when the offender had a court hearing. The remarks include extracts from some of the messages, and I've described them on the slide here, but that description is probably an understatement of how explicit they were. The offender in this case was characterised as an intimacy-seeking stalker, so the kind who thinks that the victim will eventually return their love. But in this case, when he was clearly rejected, that turned to anger and resentment. And this case actually resulted in 3 separate stalking charges. In contrast, we have the case of DPP and Brian, which involved a shorter burst of intense harassment at the end of a relationship. That relationship had ended because the offender was violent towards the victim. She left, and in the immediate aftermath, he bombarded her with calls and messages trying to persuade or coerce her to come back. It was intense, and given what had already happened in the relationship, there was clearly potential for physical violence, but it all occurred over quite a short period. There were psychological issues in the background, of a type that's unfortunately common in family violence cases. This overall behaviour pattern of a controlling relationship and escalating harassment at the end of it was repeated in a lot of family violence stalking cases. And many of these types of cases included additional charges related to physical violence that did eventuate following the stalking course of conduct. Even with those that didn't, there was often quite intense intrusion, so things like surveillance, loitering, and following the victim, including following them to or inside their home. So what does the case law say about how stalking cases should be sentenced? The aggravating features that are identified in case law actually track pretty closely with what's identified in academic research as marking out serious or risky cases of stalking. So that includes whether stalking is related to family violence, especially if it occurs following the end of a relationship that was already violent. If the stalking has continued for a long time, or if it's stopped and restarted, especially if the victim obtained a family violence order or a personal safety intervention order against the stalker. If the stalking was particularly intense or had an unusually severe effect on the victim, and intensity might mean that there were a lot of intrusions close together, or that the individual intrusions were of a very severe nature. If the stalking was particularly calculated, or if the offender refuses to take responsibility, including if they blame the victim, and if the context suggests that the stalking was going to progress to physical or sexual offending. If the stalking has already included other very serious offending, then the offender will probably also be charged with those offences and sentenced for them as well. In terms of mitigating features, one that pops up quite often is diminished capacity or diminished culpability due to mental state. There were a few stalkers who had delusions that their victims returned their affections and perhaps would appreciate what they were doing, or who had neurodisabilities that diminished their ability to understand why they needed to stop. Those factors tended to mean that the stalkers were considered less morally culpable. Finally, before we get into the data, I have a warning about interpreting it. Many of the behaviours that are captured by Section 21A are criminal in their own right. For example, if someone is stalking by making threats to kill, that could lead to a threatening to kill charge. If there's a family violence intervention order in place, it might also be a breach of that order. In the cases in our dataset, there are 2 possibilities for how this might be treated. Either you might have only a stalking charge, and the other behaviour could be treated as context for the stalking. Or there might be separate charges for each of those behaviours. As I mentioned, in DPP and Stevens, our case study about long-term fixated stalking from the previous slide, that offender made threats to kill, but those threats were dealt with as part of the stalking charge. In contrast, we have the example of Fuyava. In that case, the defendant was the ex-partner of the victim. He was sentenced for a series of events, beginning with an incident where he repeatedly threatened to kill the victim while holding a large kitchen knife. Over the next few days, he sent her abusive and threatening text messages and called her repeatedly. He also broke into her house and destroyed a number of sentimental items as well as a screen door, and took pieces of her jewellery, her university ID card, and her car key. This led to a total of 6 charges. 1 of threatening to kill for the incident with the knife, 1 of burglary for breaking into the house, 2 of criminal damage for destroying sentimental items and damaging the screen door, 1 of theft for taking the jewellery, car keys, and ID, and finally the stalking charge covered the messages and calls. Whether the other offences are treated as surrounding circumstances or charged separately tends not to have too much of an effect on the end sentence. That's because there are rules about double punishment, and courts are allowed to adjust a sentence to an extent in order to take account of uncharged acts. But there's also a third possibility, where the underlying behaviour pattern is stalking, but it's captured using a one-off incident-based charge and not a stalking charge. For example, if Stevens had been dealt with using a threat charge instead of a stalking charge. In that scenario, the case would not be in our dataset. So as we now look at data on stalking offences, the caveat is that it doesn't cover all of the stalking behaviour that was dealt with in the criminal justice system. With that in mind, we'll look first at stalking offences recorded by police. Then we'll move on to stalking that was sentenced in the courts. And finally, we'll look at offending after a sentence for stalking. This graph shows the overall number of stalking offences recorded by police in Victoria across the study period. The total was 25,130, so on average, about 2,500 a year. Until about 2014, the number of stalking offences police recorded was climbing each year. Between 2014 and 2015, it fell back a little bit, and then it was roughly stable up until 2020, when there was a slight jump. 87% of recorded offenders were male, and 80% of recorded victims were female. Nearly 60% of stalking offences were just recorded as stalking, with no further detail about the behaviour involved. About half of the remainder did specify a behavioural element. Most often, that was contacting another person. The other half of the remainder specified a mental element, and the most common mental element was acting with intent to, or in a way that a reasonable person would expect to, cause the victim fear or apprehension for their own or someone else's safety. When police record an offence, there's a field for the start and end date. Since stalking is a course of conduct offence and it can be committed over a long period of time, we wanted to get an idea of how long each offence was recorded as occurring for. This graph shows those recorded durations. And you'll notice that there's a high proportion of offences recorded as occurring over a single day. Unfortunately, we can't tell you how many of those are accurate. When we're working on a report, we invite a number of people from different organisations to a stakeholder roundtable, and we show them our preliminary findings so that they can have a conversation with us and with each other about those results and how to interpret them. But with this data, there was no consensus among our stakeholders about how to interpret it. We think some of those very short durations are probably either a result of inaccurate data entry, or they might be the date of a single specific incident. For example, the date the stalking started, or the date of a specific contact. We concluded that the average duration of a stalking course of conduct is at least 86 days, but probably longer. And the median duration is at least a week, but probably more. Academic research finds various different average and median durations, but they tend to be longer than what we have here, even if you exclude those 1 days. The medians tend to be in the range of months rather than weeks, and the averages can be up to a year or two. There's another practical reason why our durations might be shorter, which is that if a police officer is responding to a report of a crime, that can happen before the behaviour stops. If the behaviour continues, or if it restarts and leads to a second charge, that won't necessarily be apparent in this data. And as you already saw with one of our case examples, we do know from the higher court's remarks that at least some people were sentenced for more than one stalking charge that related to a single victim. So who is stalking and who is being stalked? Unlike sentenced offence data, which only has details about the offender, Victoria Police recorded offence data also tracks some information about recorded victims. This slide breaks down recorded offences according to the relationship between the victim and the offender. The light grey shading in the background shows the proportion of recorded offences where the relationship was known. The dark grey is recorded offences where the relationship was not known. If you look at the yellow columns, they show that the number of stalking offences by former partners more than quadrupled, from 204 in 2011 to 914 in 2020. Now, part of that increase is because the relationship is being recorded in more cases, but it doesn't come close to explaining all of it. Stakeholders also told us that the Royal Commission effect was a factor, meaning greater recognition of what family violence can involve, greater social intolerance of that, and improved policing practices around it. We also heard that technology now makes it easier to show evidence for a pattern of stalking behaviour, for example, using a message history to show repeated contact. Looking at the change in 2020, there was a drop in light blue current partner stalkers and an increase in orange stranger stalkers. We heard that the increase in stranger stalkers was potentially related to undesirable behaviours shifting online, bearing in mind that if people are stalking over the internet, they're not necessarily revealing their identity. The drop in current partner stalkers was potentially partly to do with reduced opportunity for some stalking behaviours. For example, it's hard to follow someone you live with during a lockdown when neither of you are leaving the house. But there could also be significant obstacles to reporting when victims were physically close to their partners, and that's likely to be a big contributor too. Time to look at the sentencing data. 95% of stalking charges and cases are sentenced in the magistrate's court, so we're going to start there. To give you an idea of the numbers, over our study period, we had just over 25,000 recorded stalking offences. Just under 7,000 charges were sentenced by the courts in 5,438 cases. And almost 6,500 of the 7,000 charges and 5,170 of the 5,438 cases were sentenced in the magistrate's court. This graph shows the number of stalking cases that were sentenced in the magistrate's court each year of the reference period. From 2016 onwards, we have family violence indicator data, and we've split the columns accordingly. Cases with a family violence indicator are yellow, and those without a family violence indicator are blue. Along with the recorded offence data we saw before, this shows us two things. First, stalking is strongly associated with family violence, and the gender data shows us that it's a strongly gendered crime. Second, the number of charges and cases increased from 2011 to 2016 or 17, but then there was a decline in the number of stalking cases sentenced. This dataset includes 2020, and that year was an outlier in a number of ways. But in this instance, some of that drop-off looks like it's part of a pre-existing trend. So why is that happening? I mentioned earlier that stalking behaviours aren't always prosecuted using stalking offences. What seems to have happened since 2016 is not that there was any decrease in stalking behaviours or necessarily in prosecutions. Instead, we think those same behaviours are being prosecuted using other offences, increasingly breaches of family violence orders. Over the same period where we saw that decline in stalking cases, there was an increase in the number of family violence orders imposed by courts, partly due to increasing community awareness about family violence and changes in police and court practices. Also, the offence of persistently breaching a family violence order, which was introduced in 2013, has become more common. That offence has a maximum sentence of 5 years imprisonment, less than stalking at 10 years, but significantly more than a simple breach of family violence intervention order at 2 years. It requires 3 breaches of a family violence intervention order or a family violence safety notice within a 28-day period. In some ways, that's less complex than proving a course of conduct because the elements are so clearly defined. It's also easier to prove in that it doesn't have a specific mental element the way the stalking charge has. More generally, our stakeholders told us that stalking charges are often a target for plea negotiation, meaning that they often get negotiated down to incident-based charges. As part of our research, we also examined the non-stalking offences that were sentenced in the same case to get a sense of the overall set of offending being dealt with. Now, as I mentioned earlier, which charges are ultimately applied can vary a bit from case to case. We also can't be sure from the sentencing data whether these offences were part of the same course of conduct, or indeed whether they involved the same victim as the stalking charge. But that said, once again, we see a pattern that's fairly typical of family violence-related offending. Breaches of intervention orders, especially family violence orders, were present in almost half of all stalking cases, which is an exceptionally high rate. Most of the other common offence types are also common in the context of family violence: assaults, threats, property damage, and harassment. There was also a fairly high rate of cases where offenders were sentenced for multiple stalking offences, 13%. But again, there's no way to tell whether those involved the same victim. When we examined the higher court sentencing remarks, which do give us more of a narrative of events, those had examples both of people being sentenced for multiple stalking charges in relation to the same victim and multiple charges in relation to different victims. There was only one co-sentenced offence that was more often committed by female offenders than male offenders. That was using a carriage service to menace, harass, or cause offence, which is a charge that applies when someone uses the phone or the internet to make threats, harass, or offend someone. So what kinds of sentences did people receive for stalking? This graph shows the sentences for every stalking charge in the reference period. Sometimes people can receive more than one sentence on a single charge, and where that happens, we count the most severe sentence. Overall, sentences for stalking in the Magistrates' Court were quite severe. About a third of charges received an immediate custodial sentence, which nearly always means imprisonment. Another third received a community correction order, or in 2011, a CBO. The final third received one of an adjourned undertaking, a fine, diversion, or another sentence, and most of those other sentences were suspended sentences. Factors associated with more severe sentence outcomes included male offender gender and the presence of a family violence flag in the case. And this graph shows us how those sentence types changed over time. I've bolded the lines that represent the most severe sentences: imprisonment in dark blue and community orders in orange. You can see that the imprisonment rate increased steadily from a quarter of all outcomes to a third between 2011 and 2019. And then in 2020, it spiked to 59%. The overall trend, excluding 2020, isn't far off what we see in the Magistrates' Court more generally. The overall imprisonment rate has been rising in general. Similarly, that yellow line at the bottom is largely made up of suspended sentences, and they were abolished around 2014. The 2020 spike was largely due to changes in court operations. During 2020, the courts tended to prioritise cases where either a defendant was on remand or they were likely to receive imprisonment, and those tended to be the most serious cases. It may be that that trend will reverse somewhat as the courts deal with resulting backlog, which could include some slightly less serious cases. It's also worth noting that a time-served sentence appears in this graph as imprisonment, and so does a combined sentence of a CCO alongside imprisonment. So not everyone in that imprisonment group is necessarily spending much more time in prison after their sentencing hearing, and some people in that group will also have some level of community supervision, treatment, and so on after they're released because they receive a CCO as well. If you're interested in time-served sentences, by the way, we published a report on those in 2020. Where were people sentenced? This is a map of Victoria, broken into its 6 justice regions. Greater Melbourne at the bottom, and then working clockwise, Barwon Southwest, Grampians, Loddon Mallee, Hume, and Gippsland. Under each of those, you'll see the estimated proportion of Victoria's adult population living in the region, the proportion of stalking charges sentenced in each region, and the rate of imprisonment sentences imposed on those stalking charges. As is too often the case, rural and regional Victoria was overrepresented, accounting for 24% of Victoria's adult population, but 33% of sentenced stalking offences. That regional overrepresentation mostly came from Gippsland, which has 4% of Victoria's adult population, but accounted for 12% of sentenced stalking offences. And although the rate of imprisonment was fairly stable, in the low 30s in most of the justice regions, in Gippsland, 40% of stalking charges resulted in imprisonment. We heard that this was probably due to the compounding effects of disadvantage. Gippsland suffers from higher than average levels of economic disadvantage, unemployment, mental illness, family violence, methamphetamine use, and intergenerational trauma. We also heard that accessing support services there can sometimes be difficult. These factors probably combine to increase the seriousness of stalking behaviour, and they also contribute to other difficulties and other forms of criminal offending, meaning that more stalking offenders probably have a criminal history and are assessed as being at higher risk of further offending. A couple of slides back, I mentioned CCOs. So what does a CCO involve? This graph shows the rates of the four most common optional conditions attached to CCOs. We have assessment and treatment conditions in green, community work in yellow, supervision by corrections in blue, and judicial monitoring in grey. The first four graphs are for our 3 reports monitoring the use of CCOs and our report on animal cruelty offenders. And you'll notice that they're all quite similar. But the graph for stalkers is slightly different. Their rates of unpaid community work were lower, their rates of assessment and treatment conditions were higher, and their rates of supervision and judicial monitoring were also higher than offenders generally. When we looked at offenders who received a CCO as well as imprisonment, the rate of assessment and treatment conditions increased to almost 100%. This makes sense because the research on stalking shows that stalkers often have psychological or neurological conditions that contribute to that stalking behaviour. And our stakeholders told us that CCOs were often used for therapeutic purposes. It also makes sense when you consider that there was a fairly high rate of remand and time served sentences, meaning it wasn't uncommon for people to have little or no time left to serve in prison after the sentencing hearing. So what kinds of therapeutic purposes do those CCOs serve? There was one program in particular that was highlighted to us for its effectiveness with stalkers, and that is the Problem Behaviour Program provided by Forensic. It's a specialist treatment program run by forensic psychologists, and it's community-based. It takes referrals from a number of sources, but most of its referrals come from Corrections Victoria. And that can happen in one of 2 ways. Either someone receives a CCO sentence with an assessment and treatment condition that specifically refers them to the Problem Behaviour Program, or they receive a CCO with a general assessment and treatment condition, and the case manager selects the Problem Behaviour Program. So there are 2 important points here. Firstly, if this program is going to be a sentence requirement, that sentence needs to include a CCO. And secondly, for either of these referral pathways to occur, someone involved in the case needs to recognise the underlying behaviour pattern as stalking. That's more likely to happen when there's a stalking charge involved in the case. Let's move on quickly to sentences for stalking in the higher courts, the County Court and the Supreme Court. This graph shows the sentence types imposed on stalking charges over our 10-year reference period. I haven't broken it down into yearly figures because there was no discernible trend. That's because we're only dealing with about 18 charges and about 12 cases per year on average. The green represents stalking charges that received an immediate custodial sentence, 82% of all offenders. The yellow shows CCOs and grey is any other sentence. The average term of an imprisonment sentence on a stalking charge was 14 months. There was no apparent trend in that over the reference period either, and that's only the stalking component, so there may have been other charges that also attracted a sentence. Almost all the offenders in the higher courts were male. And this table gives you an idea of why there was such a high imprisonment rate. When we examined the sentencing remarks, it became clear that prison sentences were often at least partly due to other extremely serious offences being sentenced in the same case. There were 48 cases where stalking was the most serious offence, and the rate of immediate custodial sentences for those was lower, although it still made up 2/3 of cases. These are the 6 most common co-sentenced offences in the higher courts. Assault and injury offences were most common by some margin, appearing in over a third of cases. Burglary offences were also very common, and most of those were aggravated burglary offences. Around a fifth of stalkers sentenced in the higher courts were also sentenced for sexual assault offences, and around a fifth were cases where an offender was sentenced for multiple stalking offences. Finally, before we look at reoffending, let's move on to the Children's Court, where there were 186 charges in 155 cases. Unlike the higher courts, though, despite the small numbers, there is apparently a trend. The number of stalking charges and cases spiked in 2013, but since then, it's decreased fairly steadily. That decrease over time is a feature of the Children's Court generally. The number of cases being sentenced in the Children's Court has been reducing fairly significantly over time. We tried to find an explanation for the 2013 spike, but nothing definitive came up. And considering how small these numbers are, it could be something fairly idiosyncratic. 69% of the offenders sentenced in the Children's Court were male, and just under a third of cases had a family violence indicator in the years we've had reliable data. So the offence seems to have been less strongly gendered in the Children's Court than in the adult courts. And that's consistent also with that very high prevalence of family violence in the adult courts. The average age of offenders sentenced for stalking in the Children's Court was 16. And for the Children's Court, as for the other courts, we looked at co-sentenced offences. There were 6.9 charges per case on average. That sounds very high, but it's roughly consistent with the Children's Court overall. And it's that high partly because the Children's Court tends to consolidate cases so they can be dealt with more efficiently, more so than the adult courts. Threat and assault offences were the most common offence type sentenced alongside stalking. And just over 1 in 10 offenders were sentenced for more than one stalking offence, which made it the 8th most common co-sentenced offence overall. There was a lower rate of intervention order breaches in this cohort compared to the adult courts. And there's been limited research on children stalking, but there was one study done in Victoria and published in 2009. And this data is consistent with the findings of that research. It found that a lot of stalking among children was bullying related, but that there was also a group of mostly boys who stalked their ex-girlfriends after a breakup. And it found that threats and assaults were common. Unusually, we found that there were higher rates of co-sentenced assault and injury offences for girls. In fact, assault and injury offences were the most common co-sentenced offence for girls. They were third for boys after threats and using a carriage service. We don't know for sure why this is, but it might be that girls whose behaviour was slightly less serious tended to be dealt with in other ways. For example, through their school's disciplinary processes, rather than through the courts. And this graph shows sentence outcomes for stalking charges sentenced in the Children's Court by gender. Boys, in yellow, were sentenced for 130 charges, and girls, in green, for 56. The most common outcomes over the 10 years were good behaviour bonds and probation, followed by diversion. Boys were far more likely to receive youth supervision orders for their stalking charges than girls were. But otherwise, the distribution of outcomes was more equal than in the adult courts. Sentences in the Children's Court have been becoming less severe over time. The most severe of these outcomes, youth detention and youth supervision orders, were not imposed in 2019 and 2020. On the other hand, diversion, which is the least severe outcome and isn't technically a sentence, was only available statewide in the second half of the reference period. But by 2018, most stalking cases in the Children's Court resulted in diversion. This trend has been fairly consistent despite the low case numbers. And these changes are also broadly consistent with the Children's Court in general, including the uptake of diversion once it became available. Diversion is now the most common sentence outcome in the Children's Court overall. Next, reoffending. For this analysis, we examined the occurrence of sentences for stalking offenders subsequent to their stalking case. We took every stalking offender who was sentenced in 2015 or 2016, 1,132 people, and asked how many of those people received another sentence within 4 years of their stalking sentence. And this is the cumulative reoffending rate. So of our 1,132 people, 29% reoffended and were resentenced within 1 year. By 4 years later, over half of the cohort had been sentenced again, 631 people. This is similar to the reoffending rate of family violence order breach reoffenders, animal cruelty offenders, and threat offenders, which are other specific groups the Council has previously examined. In total, 18% of people had a subsequent violence offence, meaning an assault or related offence other than a threat. 8% of people had a subsequent sentence for another offence against Section 21A. And I've sketched that on the graph using a dotted line because we don't know how many of those people also had a violence offence. This statistic about further stalking will be affected by the fact that stalking behaviour isn't always charged as a stalking offence. One expert stakeholder told us that the 8% figure vastly underestimated the true prevalence of subsequent stalking behaviour after a sentence. So how many subsequent sentences is that? Well, we already know that 44% of stalkers had none. 23% of stalkers had a single subsequent sentence. That means a third of stalkers had more than one additional sentence within 4 years. And about 6% were sentenced at least 5 times within 4 years. We also analysed what type of offences people committed and how that varied by offender and case characteristics. There's a full breakdown in the report, but it's a very complex heat map table, so I've only taken the highlights for this slide. The first finding is probably not a shock. Male offenders had higher reoffending rates than female offenders across the board, and especially higher rates of family violence order breach reoffending. Offenders in family violence cases had higher rates than offenders in non-family violence cases of reoffending overall, violent reoffending, family violence reoffending, and subsequent stalking. The highest overall reoffending rate was among offenders aged under 18 at the time of their sentence, 82%, although there weren't very many of those offenders. Overall, reoffending rates tended to fall with age. Offenders aged over 50 had reoffending rates of 35 or 36%. But there was one important outlier group, which was offenders in their 30s. Offenders aged 35 to 39 were the second most likely to reoffend overall after children. They were the most likely, along with young adults, to be sentenced for stalking again. And they were the most likely of any age group to be sentenced for breaching a family violence order. This appears to be a family violence-related phenomenon. It's common with family violence offending to see a slightly older age range. One of our stakeholders also commented that people in that age range tended to take the end of a relationship especially hard, and that family violence stalkers in their 30s often stalked the same victim for a comparatively long time. Finally, let's look at a summary of reoffending across the Victorian Justice regions. This is the same map from before. For each region, we have the number of offenders sentenced in 2015 or 2016, the overall reoffending rate of those individuals, regardless of where the subsequent sentence occurred, and their proportion who were sentenced again at least once for another stalking charge in the subsequent 4 years. As we see with many offence types, there was a higher rate of reoffending in the regions. All the regions except the Grampians had a higher overall reoffending rate than Greater Melbourne did. But in terms of subsequent stalking, the distribution was much less even. There were very few offenders with subsequent stalking sentences in the Western regions. But Hume and Gippsland had higher rates of subsequent stalking than Melbourne. This high rate of reoffending is most likely to do with there being more limited access to services, treatment and support in the regions, as well as the issues that I've already mentioned around disadvantage. So what are the takeaways? Firstly, there's a strong link between recorded and sentenced stalking and family violence offending. For the years we've had reliable data, over half of all recorded offences were linked to family violence. Over 2/3 of cases in the Magistrates' Court were linked to family violence, and at least 39%, but probably more than half of cases in the higher courts, based on our analysis of sentencing remarks. Further, 38% of all cases in the dataset involved a breach of family violence order sentenced alongside the stalking charge. That's an exceptionally high rate, especially when you consider that not only is it likely that the stalking itself was linked to a context with some connection to family violence, but also that there was an active family violence order in place, either prior to the stalking or soon enough afterwards that a breach of that order became part of the same case. There's been some change in sentence outcomes over time. Community correction orders and fines have become less common, and imprisonment and to a lesser extent adjourned undertakings have filled the gap. That's consistent with broader trends in the Magistrates' Court and with what we've seen in other reports. It's also fairly consistent with the fact that family violence is associated with more severe sentence outcomes. Section 21A is broad and flexible. As a result, it can capture a wide variety of different behaviour, different durations and different intensities as shown in this matrix. If the course of conduct includes various independently criminal acts, there's quite a variation in what additional charges those may lead to, if any. Our analysis of sentencing outcomes doesn't suggest that that choice has much of an effect on end sentences, but it does mean that the statistics on stalking offences can be a little bit opaque. Finally, there's also a lot of stalking behaviour that can be, but isn't necessarily, captured using Section 21A. It's an important part of the job of Defence Counsel to test every element of the charges laid and to advocate for the least severe outcome that's appropriate. But as we saw with the problem behaviour program, there can also be flow-on effects. Whether someone receives specialised treatment can depend on the underlying behaviour being recognised as stalking, and that's much more likely when there's a Section 21A stalking charge in the case, especially because there's such variety in stalking behaviour patterns. The risk is that if the behaviour is not accurately identified as stalking, then the rehabilitative response a person receives may not be as effective as it could be. That concludes the seminar. If you've enjoyed this and you want more sentencing content, we have various social media accounts as shown here. Our website has all our reports and statistical tools, including the stalking report, of course. And you can also use our website to sign up for our mailing list to stay up to date with our research, publications, and resources.